All right. Hello, everyone. We'll just a couple more minutes for a few people to join. All right, so welcome everyone to our webinar on Commercial Leasing 101, Understanding Heads of Agreements. My name is Tuhina. I'm the practice leader in our leasing team, and I'm joined by my colleague Sarah, who is also a lawyer in the leasing team. So we'd like to start off today with an acknowledgement of country. LegalVision acknowledges and pays respect to the past, present, and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters are situated on, and the various lands on which those of you who are joining us today. So before we begin, a few quick housekeeping matters. So you will be emailed a copy of this webinar recording as well. At the end of the webinar, we will also be answering some of your questions. So please submit your questions through the webinar chat function and we'll answer them at the end. And finally, there will also be a short survey at the end. So if you could please take a few minutes to complete that. So today, as I said, we'll be discussing what is a heads of agreement, binding versus non-binding heads of agreements, some key commercial details that should be included in your HOA, specific requirements for your business or other special requirements, and some general pitfalls. And at the end, like I said, we'll have a Q&A. So I'll now pass on to Sarah, who will talk you through what a heads of agreement is.
So a heads of agreement, you may have also heard it referred to as a term sheet or a letter of offer, as we'll be addressing it a lot in this webinar, a HOA. They're all words for the same thing, but essentially a heads of agreement sets out the key commercial terms between the parties before they enter into a lease. Now, there's no requirement to enter into a HOA, but it does help the parties to understand the key commercial terms and make sure they're set out. Ideally, we'd like to see a heads of agreement in a written format, and that could be a formal written format or an email agreement, but we do often see situations where parties have just verbally agreed to the terms. So what are some of the key commercial details that are supposed to be in a heads of agreement? We've just listed some here, so I'll run through them. Of course, the heads of agreement needs to cover the description of the premises. We want to make sure that the address is accurate. It doesn't have to be the title details, but definitely an accurate address. And you know, if it's a unit 1 or a unit 2, we want to specify that. The amount of rent and what the rent reviews will be. If you want to negotiate these terms, now is the time to do that. An accurate outgoings description, and that may include things like land tax, utilities, maintenance, gardening. Ideally though, that should all be agreed at the start. And what we'd like to see as well is if you're only leasing a portion of the building, or you know, you don't have to pay 100% of the outgoings, the percentage and even an estimate of how much those outgoings will be. A heads of agreement should also set out the start date, the term for the lease, and if there'll be any options to renew. The heads of agreement should also set out the permitted use. Now, it's really important to get this right from the start, as if you're a tenant, this will be the only thing you can use the premises for, and if you're a landlord, you want to make sure that the tenant is obviously only using the premises for that permitted use. It'll also set out whether there's any security, so that may be in the form of a bank guarantee or a deposit. Often you'll see in a heads of agreement a make good clause, and that will set out the parties' obligations at the end of the lease and the conditions in which the premises must be returned to the landlord. So that'll include things such as removing the tenant's property, or repairing damage, or even conducting works to return the premises to the condition they were in at the commencement of the lease. There also should be a provision for if the tenant has to pay a deposit to secure the lease, so that's usually 1 month's rent in advance, and whether or not that deposit is able to be refunded if the parties don't proceed with the lease. The last thing that we often see in a heads of agreement is who will be bearing what costs for lease preparation and negotiation, noting that if you're a retail tenant, the landlord can only recover costs for negotiating the lease in most states and not for preparing, but that's going to depend on what state you're in. Next, Tuhina is going to touch on whether a heads of agreement is binding versus non-binding and what that means.
Thanks, Sarah. So broadly speaking, the heads of agreements can be in three different categories: immediately binding, non-binding until a specific trigger event occurs, or just generally non-binding. So what do I mean by binding? That's essentially saying that the parties are legally obliging themselves to perform the relevant contract, in this case, a lease. So in other words, upon signing the heads of agreement, the parties are agreeing to be bound by the lease and to perform the lease for the duration of the term on the terms and conditions that have been set out in the heads of agreement. Even if there are some specific details that may need to be fleshed out, and even if a formal lease document has not been signed, if you have signed a binding heads of agreement, it may mean that you have essentially locked yourself into that lease. You can also have non-binding heads of agreement until a specific trigger event occurs, and usually that may be landlord execution or landlord board approval. So what this means in practice is that upon signing the heads of agreement, it's not yet binding, no one is locked in until that trigger event has been satisfied, and upon that being satisfied, so upon the landlord receiving board approval, for example, the heads of agreement becomes binding and the parties are locked in to continue with the lease. And finally, you can have heads of agreements that are just generally non-binding. And that means even if the parties have signed it, neither one has legally committed themselves to the lease, and effectively either party can walk away from the deal. Moving on to the next slide. So it's really important, especially if you're a tenant, to determine whether or not the document and the HOA that you are signing is binding or non-binding. Usually, a HOA will expressly state whether or not that is the case. And if it doesn't, the general assumption is that the HOA is not going to be binding. And again, so that means either party is free to walk away from the deal. Particularly when there is a dispute about whether or not a HOA was binding, then it may also turn on whether the intention of the parties was in fact to enter into a legally binding arrangement upon signing that document, and that can be evidenced by surrounding emails or other communication. So for example, if you are a tenant and you have signed a heads of agreement and you email that heads of agreement to the landlord or the landlord's agent, and in that email you say words to the effect of that you are now binding yourself to the lease and you are committing yourself to continue with the lease on those terms, then that may go to proving the fact that you did intend to enter into a binding HOA. So the market standard position, though, is usually most heads of agreements are expressed to not be binding on either party until formal lease documents have been signed. And so again, the other risk to be aware of with binding heads of agreements is that not only will you may be legally obligated to perform the lease, you will have to do so on the specific terms that have been negotiated in the heads of agreement. And so whatever the term may be, whatever the rent may be, you may be limited in being able to negotiate those any further. Particularly for tenants, it's important to look out for HOAs that are expressed to be binding on the tenant, however, not binding on the landlord. And what that means is, upon signing and returning the document, the tenant is effectively locked into continuing with the lease and cannot withdraw from it. However, the tenant does not yet still know whether the landlord has received for example, its board approval to be able to continue with the lease. And so there is a risk that the landlord can still walk away, and that sort of limits a tenant's ability to potentially find other more suitable sites because they have locked themselves into this obligation to proceed with the lease, whereas the landlord can still turn around and walk away from the deal. So it's really important to be clear about that, and ideally the HOA should expressly state what the intention of the parties is, which is usually that it's not binding until lease documents are signed, and so either party can still walk away from the deal. So now Sarah's going to talk about some special requirements for your business and additional terms in the HOA to look out for.
So we've already touched on all the standard commercial terms that we want to see in a heads of agreement, and now I'm going to touch on some of those more detailed items that you might want to see but won't be in every heads of agreement. So one of the really important items here is fit out works and any early access. So if either the tenant or the landlord are doing any fit out works, we want to see that documented in the heads of agreement. And it doesn't have to be super detailed, but ideally we'd like to see a list of works, especially if the landlord has agreed to provide specific items before the tenant can take possession. And it would be good also to see a rough timeline of those works in terms of when the tenant will be getting handover and how long their fit out period would be. Often tenants will find that they're offered a fit out period of anywhere between 4 and 6 weeks. Obviously that's going to change deal to deal depending on your arrangement, but if you are offered a fit out period, it's ideal that that's documented in the lease. And that's what we're talking about when we say early access. That's where you get to access the premises a few weeks before the actual commencement of your lease to conduct your works. By the same measure, if the landlord's offered the tenant any incentives, and incentives can include anything from a rent-free, a fit-out contribution, which is a cash contribution towards the fit-out works that you do, or a rent abatement. And a rent abatement could be, you know, over the whole term of the lease, or it might only be 1 or 2 years or a few months. We'd want to see that documented. Often incentives are offered to entice tenants to enter into the lease, and if that is something that's been offered to you, you want to make sure that you've documented that in the HOA and what it looks like. Something to be careful of as a tenant is that often landlords will include what's known as a clawback provision, and that gives the landlord the ability to essentially take back some of your incentive if you either terminate the lease early, assign the lease, or in some cases, even if you sublease or license the lease. So if you don't agree to that clawback provision, or you only agree if you terminate the lease early, then you want to make sure that's addressed at this negotiation stage with the heads of agreement. The other thing we'd want to see included is if there's any special repair or maintenance obligations. This is particularly important if you're not a retail tenant because you're not protected by the Act. For those who don't know, the retail legislation generally puts a lot of special repair and maintenance obligations on the landlord and gives the tenant a bit of protection. But you know, if you're a commercial tenant or a warehouse tenant or another type of tenant, then you may not be covered by the Act. What do I mean by these special repair and maintenance obligations? You know, it may be that the landlord has said that they will clean and repair the air conditioning before you take possession, or they might have said that they would repair a crack in the wall or something like that before you take possession of the premises. And if that's something that the landlord has said they will do, you want that documented. By the same thing, they may have said that they will have continuing obligations to service specific equipment or something like that. If the landlord's promised you that, you want that documented. So there are some other things you want to look out for as well. So has the landlord promised you as a tenant that you'll have an exclusive permitted use? What does that mean? It means if you say are a cafe, the landlord may have said that you will be the only cafe in the building. If the landlord said that you will have that, then you want to make sure that that's documented. By the same measure, landlords often make warranties about the type of tenancy mix that we see in a building. That may be that they've said there'll be 1 hairdresser, a grocery store, and 3 women's fashion stores, or in an office building, it could be that they said, you know, there's lots of medical tech companies in this building and this will be a medical tech hub, for example. we'd want to see that documented in the heads of agreement as well. And if that's something that you're interested in negotiating, either as a landlord or a tenant, the heads of agreement is the perfect stage to document that. Also, if the landlord has made any warranties to you about the availability of certain services, that could be as simple as the landlord saying, I promise there'll always be a cafe downstairs. If the landlord has said that, then you want it in the heads of agreement. Essentially what we're saying is if anything has been a verbal representation to you as a tenant, or even if you've made that representation as a landlord, you want to make sure that's documented in the heads of agreement so the parties can rely on that representation. I note with respect of air conditioning and fire safety requirements, most landlords will pass these obligations on to the tenant. So that's, usually annual maintenance of the air conditioning and annual fire safety compliant maintenance, including obtaining a fire safety certificate. As a tenant, you should be aware that those obligations are being passed on. And as a landlord, if you do want to pass those on, you want to make sure that that's documented so the tenant knows what they're agreeing to and that will be their obligation. And so it can be, documented in the lease properly once we go to drafting the lease. Tuhina is now going to touch on, as our final point, some of the pitfalls of heads of agreements.
Thanks, Sarah. So, look, to tie in some of the points that we've been discussing today, I'm just going to go through some really common pitfalls or traps when you are signing on to a heads of agreement. So the first one is, as I said, not understanding whether or not the HOA that you are signing is binding or not binding, and particularly unintentionally or inadvertently entering into a binding HOA, which means you have now locked yourself into complying with the terms of the lease for the duration of the lease, when perhaps that was not your intention. Similarly, and especially if you are a tenant, you may perhaps be under the impression that by signing the heads of agreement, the landlord is locked in and has promised to grant the premises to you. And so you may decide that you'll stop looking for alternative sites. However, the HOA is in fact non-binding, which means the landlord can still walk away and find another tenant, for example, that's willing to pay more rent. And if you're a landlord, similarly, it means the tenant may still walk away from the deal if they found a more suitable premises elsewhere. So really important to know whether or not the HOA is binding or non-binding. As Sarah touched on, it's also really important to make sure that the special requirements that are necessary for you to operate your business have been addressed in the heads of agreement. This is because what happens once it is signed is that the landlord will provide that document to the lawyers, and the lawyers will draft a lease based on the terms and conditions that are agreed in the HOA. So if your special requirement is not in the HOA, it's not going to be in the lease. And ultimately, you may end up losing some of the leverage you have to be able to negotiate some of those special requirements at that stage, as opposed to right at the beginning of your discussions with either the landlord or the agent. So those special requirements could be things like specific works that you need the landlord to undertake, or certain service connections that you require. Really important to have a think about what your business needs from the site and to address that in the HOA. Similarly, it's also really important, as Sarah touched on, to include any representations that the landlord or agent may have made to you. So even if you've got emails or communications back and forth where certain promises have been made to you about a tenancy mix or a particular anchor tenant, include those in the heads of agreement, because ultimately that means they will then be included in the lease and it means they will be enforceable. Similarly, for a landlord, if the tenant has made certain promises or representations to you, they also need to be specified in the HOA ideally. It's also important to consider whether or not you will need access to specific licensed areas. So these can be areas that sit outside the actual boundaries of your leased premises, but that you still need the ability to use and access. So for example, things like if you're a cafe, a seating area that might be on the outside footpath. or it might be access to car parks. So if you do require access to these special areas, it's important to just flag them in the HOA, and that means either the lease will contain a license provision granting you access to those areas, or the landlord may provide a separate license document. Another interesting thing that we have started to see come up quite often in HOAs is requirements on the tenant to sign and return lease documents within a certain time period of receiving them from the landlord or its lawyers, usually about 14 days. The issue with this is that it's really limiting your ability as a tenant to be able to review the lease, seek legal advice, and potentially request amendments to the document that might be required, especially if the HOA is framed in such a way so that failure to sign and return the lease documents within that time period means either you may have forfeited any deposit that you've paid, it may mean that your exclusivity period ends and the landlord can walk away from the deal. So it will depend on ultimately how the HOA expresses that obligation, but just be aware of those requirements and ideally try to get them removed. It's also important to keep a lookout for confidentiality obligations. And this is because even if you don't proceed with the heads of agreement and you walk away from the deal, the confidentiality obligations may still continue to apply. And that means you may still be obliged not to discuss either the specific commercial details or even the fact that you had these negotiations with the landlord to any other party. And you will still be bound by those obligations of confidentiality, even if the parties decide they're not going ahead with the deal. So just be aware of those in case you do, to prevent inadvertent disclosure or breach of those confidentiality obligations. And finally, just look out for or query whether or not your lease is going to contain a relocation or redevelopment clause. Now, where your lease is a retail lease, the relevant state legislation specifies the conditions around relocation and redevelopment. But ultimately, what they mean is that the landlord may have the right to terminate your lease at any time because it either wants to redevelop or renovate the entire premises or the building, or particularly if you're in a shopping centre, they might want to relocate you to a different site. And so especially in situations where you might have agreed on a specific location because of particular tenancy mix in that area, it may be a critical issue for your business if the landlord has the right to say, I'm going to relocate you somewhere else, or your lease gets terminated. And ultimately that may impact your decision as to whether or not you do proceed with the lease. So it's important to flag and have that included in the HOA, just so you are aware whether or not the lease is going to contain a redevelopment or relocation clause. So those are just some of the general pitfalls to be aware of in a heads of agreement. And we always recommend to seek legal advice on a HOA, even if it is one that is non-binding. It just saves a lot of time and hassle down the end when it comes time to entering into the lease. If the HOA has been prepared clearly, it contains all of the special requirements and the parties are on the same page as to the commercial arrangement. So look, thanks everyone. That concludes the substantive part of our webinar. You can also download our commercial leasing cheat sheet by accessing the handout section in your webinar panel. You might find the information in there useful for your review as well. We also have another upcoming webinar that you might be interested in attending on work, health and safety. What are your business's legal obligations? So that webinar is going to happen on Thursday, the 6th of October at 11 AM. So please do register using that link in the slide. So we're now going to answer some of your questions shortly. So if you haven't done so already, please submit your questions in the chat box now. While we wait for some questions to come through, I just want to take a few minutes to talk a little bit about LegalVision's membership and the special offer we have for attendees today. So LegalVision's membership is an alternative to the typical hourly rates that you might find in a traditional law firm. So for a fixed monthly fee, you are not only receiving cost certainty, but also all-inclusive service. So what that means is that includes things like unlimited document reviews. For example, your commercial lease will be, review of your commercial retail lease will be included in the membership. You can also have unlimited consultations, which means you can book as many meetings with our lawyers as you deem necessary whilst you are arranging the lease. For example, if you want to talk through your HOA, you can book a call with one of the lawyers in the leasing team and we can go through your heads of agreement with you and talk about any of the key issues. You can also talk to any of the lawyers in our other teams, including employment, trademarks, franchising, just depending on what your business needs. Your membership will also include unlimited trademark registrations and much more, again, all for a very reasonable monthly fee. We can also service any businesses, so we assist businesses right from small to medium enterprises all the way through to national and multinational corporations. So regardless of the size of your business, we'll certainly be able to assist. And as a special offer for the webinar attendees today, we're also offering a free consultation to discuss how we can help you with your commercial lease. So if you'd like to take advantage of that, please book in using the survey details that appear at the end of the webinar, or alternatively, you can just send an email to that address listed in the slide and just mention you watch this webinar and we can book you in for that complimentary consultation. So now we'll go through some of the questions that we've got here. So have a look here. So one of the questions we'll have, and I'll get Sarah to answer this for us. Why have HOA instead of directly signing the lease? Is it common to have a HOA before a lease document?
So there's a couple of reasons for this. It is I'll answer the second question first. It's very common to have a HOA before signing a lease. I actually find that most parties will have a HOA before signing a lease. The reason we often see a HOA before signing a lease is that the parties want to set out all those commercial details. They want to negotiate that all before incurring costs in instructing lawyers to draft the documents. And also it just makes it much easier when you're drafting the documents. You can include all those provisions and the drafting of the clauses in that need to be amended in a legal way. That can all be done so that when you get your lease document, it is essentially what you've agreed with the landlord. It also means that the obligations are set out initially in essentially what is a non-legal way, and you can see all the commercial terms and just understand, I mean, as a tenant or even as a landlord, what the parties are agreeing to without having to go through the lease document and decipher that. And it's much easier to change, a 3 or a 4 page heads of agreement than it is to change a 40-page lease. So I think that's why we often see heads of agreements. It's also the case that you'll often be negotiating the commercial terms of the lease with the landlord before, or in particular with their agents, before we see the lawyers being involved at the stage of the drafting of the lease document.
Thanks, Sarah. So another question we've got, which is a bit similar to what we had the first question. Why can't all these negotiations happen before the main lease is signed without a HOA? So again, HOA is not essential to have. You can, again, like we mentioned, have these negotiations and discussions on the commercial terms via an email correspondence or not advisable, but over a phone call as well, and then go straight to signing the lease. However, it just means it's easier when you have a simple document that sets out all of the terms that the parties have agreed to. And it also means when it comes to drafting the lease, the lawyers have got clear instructions as to what they are drafting. And sometimes it can be a little bit difficult to understand what exactly the agreement is when you've got multiple emails back and forth and parties negotiating this and that, and you're kind of opening up yourself to the risk of something miscommunication happening as well. So it's not essential to have a HOA. Certainly, parties often just go ahead and have a few email exchanges back and forth and go straight to signing the lease. Another question we have is, during the HOA negotiation process, can the landlord request a payment of a security deposit? Sarah?
So, yeah, during the heads of agreement negotiation stage, you'll often see that landlords do request security deposits. Like I touched on before, that's 1 month rent in advance usually, but it may change depending on the commercial arrangement. And the reason they request that deposit is usually so that, you're securing your right to be negotiating that lease, and you're saying, yep, I'm keen, I want to enter into this lease. That's why we also said earlier that if you are paying that security deposit, you want to make sure that that heads of agreement has a clause that says if you don't proceed with the lease, or if something breaks down, that security deposit is refunded to you. If you're talking about a security deposit in terms of actual security, like a bank guarantee or something like that, no, it would be uncommon for landlords to request that security, because that's normally tied to the lease document, better defined in the lease document, and there'll be some other requirements relating to it set out in the lease document, and you're normally only required to pay that kind of security that we're referring, which is usually anywhere between 2 to 6 months rent in rent that they hold for the balance of the lease. You're usually only required to pay that at the commencing of the lease so that you can get possession of the premises.
Thanks, Sarah. Another good question that's come up: if the requirements to sign and return the lease within a limited time frame haven't been included in the HOA, now the tenant's taking too much time to sign the lease as we are approaching the original lease start date, how can we negotiate with the tenants at this point? So, assuming you've got a situation where the parties have signed a non-binding heads of agreement, it's got a fixed commencement date that's coming up in about a month's time, lease documents have been issued to the tenant, and the tenant is taking too long to come back and sign and return the documents. As a landlord, you've got a non-binding heads of agreement. So essentially what that means is if you've got another tenant who's ready, willing and able to sign on to the lease, that may be something you can leverage with the current tenant and say, well, look, if you're not going to sign and return the documents to me or give me your responses, then we've got other tenants lined up. And so we can essentially just go ahead and lease to other tenants. So as a landlord, that's kind of the advantage of having a HOA that's not binding on you, because you're free to still have open up negotiations and deals with other potential tenants. So if you've got one particular tenant that's being difficult or is not signing and returning documents, then you can just say, well, I'm going to go off and find another tenant. You might also have a HOA that says, well, the commencement date is going to be fixed. And so if, as the landlord, you're expecting a specific commencement date and therefore rent payments to begin on that date, you might tell the tenant that, well, if you're going to delay in signing and returning the lease to you, we are not going to change the actual commencement date itself. That's going to be fixed now, and so any delays will ultimately be on the tenant in terms of getting access. So look, thank you everyone for submitting those questions and for attending the webinar. Thanks so much for joining us today. As I said, please do take a few minutes to complete the survey and also book in your complimentary consultation, and we look forward to speaking with you. Thank you.